The Supreme Court has sent a message to every voter in America. They are going to intrude on this election. They already have intruded. They have reversed a lower court decision which had ruled that South Carolina cannot require witnesses, a witness, to witness your ballot if you're sending in a mail-in ballot. The Supreme Court said, no, that's okay. The state of South Carolina can require a witness. This is just the beginning. I suspect we're going to hear a lot more from the Supreme Court, and you're going to hear a lot about that on The Durr Show. Already the United States Supreme Court is beginning to influence this election and influence it in a way that may very well discriminate against Democratic voters. The story is this. South Carolina enacted a statute that requires all mail-in voters to have a witness to the fact that they're voting and they're voting properly. The federal district court in South Carolina struck it down, issued an injunction saying, no, you can't do that. That burdens the right to vote. In a long, very thorough, 50-some-odd page opinion, the trial court made findings and said that there's just no reason for requiring a witness. It discriminates against people who live alone, people who are old, people who don't want to be in contact with anybody else because of the virus. It requires that you be in personal contact with someone else, that someone come to your home, be in your home, you go to their home, and they have to witness your signing the ballot. Now, already South Carolina has very, very careful procedures. You don't just get a mail-in ballot. You have to apply for one. They then check you out. And if you pass muster, they then send you the ballot, and the ballot has an envelope, and the envelope requires you to swear under oath, subject to pains and penalties of perjury and criminal prosecution, that you haven't voted before, that you're eligible to vote. So there are very considerable safeguards and deterrents against fraudulent voting, but South Carolina decided to add yet another layer of what they call protection and others call interference with the right to vote. Namely, you need to get a witness. And the trial court went to great length about how it burdens certainly people who live alone, people who don't belong to organizations, people who may live in rural areas and not have access to anybody nearby. I think particularly the elderly and the infirm who do live alone. And so the case went up to the United States Supreme Court, and the United States Supreme Court reversed both the trial court and the Court of Appeals, both of which had struck down or issued a preliminary injunction at least against the South Carolina statute. And as things now stand, the Supreme Court has said the South Carolina requirement of a witness holds, at least for votes that haven't yet been cast. A number of the justices said, and the majority said, that if votes have already been cast, the state may count those votes, but even there are factors that enter into the state's decision. Three of the justices, the three most conservative on the court, and this doesn't count the newest nominee who is not yet on the court, three of the justices went even further and said that South Carolina should not count ballots that have already been submitted, people who have already voted, based on a court decision saying that they didn't have to have witnesses. Three justices have said even those votes can and should be discounted. And so several questions arise as a matter of constitutional law. Look, the states do have considerable authority to regulate voting. That's in the Constitution, subject to restrictions. They can't deny people the right to vote based on age. They can't deny people the right to vote based on gender. They can't uh, deny the right to vote based on race or previous condition of servitude. All of that is clear, but they can impose other conditions not in the Constitution. I have my handy dandy copy of the Constitution that I take with me all the time and read, and there is just no provision in the Constitution that would even prevent a state from prohibiting any mail-in ballots. If a state were to prohibit all mail-in ballots, let's assume it's not for this election, but for future elections, from now on, everybody who votes has to vote at the polls, has to come in person, stand online, and vote. Under existing constitutional law, that might well be constitutional unless an argument can be made that de facto that discriminates against certain people, minorities, or people who are old, etc. But it would be a stretch. So the argument goes, if a state can restrict all mail-in ballots, why can't it impose limitations on mail-in ballots? And the answer to that is not so clear as a matter of constitutional law. There are many things a state can do in the abstract and completely, but once it decides to do the opposite, it can't impose unreasonable restrictions. And here the question is, once the state of South Carolina has permitted mail-in voting, and it has permitted mail-in voting, can it impose a restriction that may have the effect of discriminating based on age or race or wealth or any other factor that would be invidious? And if the answer to that question is yes, that it would discriminate, then the courts would have power, the federal courts would have power to strike that down. Go back to Bush versus Gore. In Bush versus Gore, the Supreme Court reversed the Florida decisions and said, no, you can't have recounts that deny equal protection, that count votes differently in different parts of the state based on the Chads and based on the bent this and based on rules and based on a variety of other things. So the Supreme Court has already intruded in one election, saying that it can strike down state laws or state rules or rulings by state courts that violate equal protection. But now it comes in and says, no, we can't intrude on the state law, even though this state law seems to violate equal protection to a much greater extent than the law in Bush versus Gore. After all, here you're denying people the right to vote based on factors that are personal, an unwillingness to subject themselves to the virus, the unavailability of witnesses, friends, relatives. It does have a discriminatory impact. Now, the Supreme Court decision is not final in this respect, but it is final for this election. It was simply a decision to undo the temporary injunction that the lower courts, I hate to get technical with you about this, but it wasn't a final decision on the merits based on full briefing, full argument. That case may still come to the Supreme Court, but I think we're now pretty clear about how the Supreme Court will decide. One of the most important issues in deciding on a preliminary injunction is what's called the likelihood of success. Is it likely to succeed on the merits? And the Supreme Court, by reversing the lower courts, basically has sent a message that no, it would not succeed on the merits. And so the South Carolina statute would probably be upheld. Now, the problem is that this is an invitation. This is an invitation to other states to impose restrictions on mail-in voting. A witness restriction is constitutional. What about requiring 2 witnesses? What about requiring videotape of the voting when you sign? One can just imagine more and more restrictions on voting being enacted by states, some perhaps well-motivated, some perhaps motivated in a partisan manner. Where is the line? In Rhode Island, the court struck down a provision that was a little bit more onerous. So what we're going to see, particularly in the future, are efforts by the states to impose restrictions on the right to vote by mail. Another thing that one of the justices said, Justice Kavanaugh, wrote a concurring opinion with the majority. There was no majority decision, no majority opinion. But Kavanaugh said one reason for overruling the lower court is you don't change the rules on the eve of an election. But that's an argument that cuts both ways. In South Carolina, the primary election was conducted under the injunction. That is, for the primary, you didn't need a witness. So a lot of South Carolinians now think you don't need a witness. And the Supreme Court decision is changing that. So inevitably, you're going to have a change when you have a statute that says one thing, a lower court decision that says another thing, and now you have the Supreme Court decision. So the Supreme Court decision, one way or another, will be bringing about a change on the eve of the election. It will either be changing the statute or it will be changing the court decisions, striking down the statute. It's a mess. And I think it may foretell what's going to happen after November 3rd. It already indicates that the Supreme Court is gearing up. It's ready. It will be available to strike down lower court decisions. It has the power, it is saying, to intrude on elections. And so I think you're going to see candidates and their legal teams gearing up even more for election disputes that will go to the court. Look, the only way that we're not going to have a disputed election is if the number of votes cast in person, that is, people who go to the polls, if people who go to the polls elect a president by the Electoral College without regard to the mail-in ballots, that is, if the victory on one side or another, I'm not getting political here, I'm just being analytic, if the Electoral College and the votes in the contested states are so clear that the mail-in ballots wouldn't affect the outcome, then I think we won't have a contested election. But if you have an election where candidate A, I'm trying to be specifically non-political here, where candidate A wins the number of votes in a state based on people who went to the polls, but it looks like that same candidate A may lose when all the mail-ins are counted, that's an invitation to court intervention. You're going to have the candidate who would prevail on the in-person voting go to court and say, wait a minute, you can't count those mail-in ballots. They're fraudulent. They didn't have witnesses. They violated this rule or that rule. And then you're going to get to a Bush versus Gore with people counting chads and looking at signatures and disputing votes. And we may not learn about the outcome of the election on November 3rd or December 3rd. So that's the mess we're getting ourselves into. And the Supreme Court just now has indicated it's willing to participate in that mess. It's willing to intrude. It's willing to strike down lower court decisions. It's willing to uphold state court decisions. And implicitly, it's probably willing to strike down state statutes as well if the proper case is presented to it, or state Supreme Court decisions as it did in Bush versus Gore. So in addition to not being able to predict the outcome of any election based on obviously what happened in 2016 where the polls were all wrong, we now have an added element of unpredictability. Even if one side wins the Electoral College as a result of disputed votes in key states, Michigan, Minnesota, Pennsylvania, Ohio, Florida, if those states become like Florida became in 2000, we're going to have a disputed election. We better get ready for that, because the disputes, if they take place in the court, that's one thing. That's okay, as long as they're plausible arguments, as long as they're real arguments, as long as they're not designed in a partisan way to create doubts about the outcome of the election. If they're legitimate legal protests, that's part of our constitutional system. But if they are illegitimate, or if candidates or others urge their followers to take to the streets and have protests, and protests in an emotional situation that we're in now can easily and quickly turn to violence, we're in for a very, very difficult and potentially dangerous situation. Add to that the deciding vote in the Supreme Court may be cast by a justice who was just nominated by one of the litigants and barely confirmed along partisan lines. I've just written a book about that, my Guinness record-breaking book that I wrote in 8 days, called Confirming Justice or Injustice, a guide to judging RBG's replacement. In that book, I lay out all the issues regarding whether or not the president should have nominated somebody on the eve of the election, whether the Senate should confirm on the eve of the election, whether Republicans who took one view when President Obama nominated Merrick Garland and are taking a completely opposite view now that President Trump has nominated Judge Barrett. All of those are laid out in my book, Confirming Justice or Injustice. And so we have a triply confounding potential election. A, we have a virus, which will confound the election in lots of different ways. B, we have write-in votes, more than ever before in history. And C, we have potential decisions and potentially a decision by the United States Supreme Court where the deciding vote could be cast by a justice just recently nominated by one of the litigants and confirmed along party lines. This is not a prescription for the most peaceful transition if the sitting president loses the election. This is a prescription for potential violence, one hopes not, certainly at the very least for potential litigation and for great uncertainty. Look, I think every American will join me in hoping that whatever party you're for, whatever candidate you're for, that the election is decisive, accepted by all sides, that if there is to be a transition, the transition is peaceful. If there is no transition, the losing candidate will gracefully concede the way Richard Nixon conceded to John F. Kennedy in a highly contested and, in the mind of many historians, very disputed election, and the way in which Al Gore, in a very dignified way, conceded an election which was decided essentially 5-4 along partisan lines by the United States Supreme Court. So stay tuned. We're going to be going over these issues between now and the election on a regular basis. We'll be going over election issues, we'll be going over pandemic issues, we'll be going over the Supreme Court, particularly when the Supreme Court confirmation process begins in the Senate. We'll be covering that in great detail. I promise you, not only because of the news, but because it's my show. I promise you, you will never be bored. Now it's time for your calls. Remember, you can call in 24/7 and I will answer your questions. First caller.
Alan, that's simply a stupid question. Of course, the president is in charge of his own doctors. The doctors, just like your doctors, report to you, and you're in charge of your doctors. The doctors on staff at the White House do what the president wants.
You're probably right, but there is one wrinkle. Remember that the president's doctors are members of the armed forces. He is their commander-in-chief. Technically, he can probably tell his doctors what to say. They're soldiers. He's the commander-in-chief. I doubt very much he's done that. I'm sure the doctors are free, subject to their Hippocratic oath and to the various laws, the HIPAA laws. But it's a complicated issue because the president has two kinds of doctors, his own personal doctors, and then doctors who are employees of the United States government and employees of the armed forces. and he is the commander-in-chief. That complicates it just a bit. Hey, Matt, you're calling from Boston. What's your question?
I am just calling to ask you today what you think the political implications are of the president possibly returning to the campaign trail, maybe while he is still contagious. Do you think that would be a good idea? And what do you think the campaign is going to look like going forward if he cannot test negative within the next few days? Have a good one.
Great questions. I don't know about the political implications of the president's illness. That's for pollsters and politicians. Personally, I would like to see the president not go to campaign events where he can inadvertently spread the illness. I'm sure he will wear a mask when he speaks and will socially distance, but health has to come first. We live in an age where you can campaign virtually, you can campaign from the White House. I would think it would send a better message that health comes first if he limited his campaigns to virtual, and if the debate, which probably will go forward, could be conducted either in separate rooms or with a separation from the audience. I think that we have to demonstrate to all Americans that this is a serious and highly contagious disease and that people who get it can die. Hopefully our president will recover, but 200 and some odd thousand people have already died. And so we have to send the appropriate messages to Americans to wear masks, wash hands, socially distance, and do whatever is necessary to prevent the spread of this terrible pandemic. Tom, you're calling from Illinois. What's your question?
I was wondering a little bit more about your ties to sex criminal Jeffrey Epstein. I was wondering why you were listed on the flight logs for his so-called Lolita Express. And I am wondering why, why you were known to hang out at his island, known as Little St. James Island. So if you could call me back, please do not hesitate. If you have anything to say, just let me know.
I have plenty to say. Thank you. I never hung out on his island. I was on his island once with my wife, my daughter, Professor Michael Porter of Harvard Business School, his wife, and relatives. This was before any women were on the island or it was ever called by any name. He had just bought an island. I had an academic acquaintance with him. He invited academics to his places for very serious matters. I met Nobel Prize winners through him. He was friendly with the president of Harvard, the provost of Harvard. He contributed millions of dollars to Harvard. My acquaintanceship with him was purely academic, and it ended on the day he was arrested, and I found out that he was being accused of serious crimes. At that point, I became his lawyer. He paid me for every single second that I gave him advice. Of course, I flew on his planes, never, ever, ever with any young women, as the records will clearly demonstrate. I flew with the other members of the legal team to meet him. I flew with my nephew once to see astronauts taking off for outer space. Every single trip, a handful, on his planes were for professional or other reasons. The records will show there was never any inappropriately aged person on any of the planes. And let me be very, very categorical. During the time I met Jeffrey Epstein till today, I've had sexual contact with one human being, my wife, of 30-something years. I never met the woman who accused me. She is committing perjury. She should go to prison. Her lawyers should be disbarred. She told her best friend, and we have it on tape, that she was pressured into falsely accusing me by her lawyers. Her own lawyer has acknowledged in a surreptitiously recorded tape recording that she was wrong, simply wrong to accuse me, that I couldn't have been in any of the places that she was. Let me be absolutely categorical. I did nothing wrong with regard to Jeffrey Epstein. My acquaintanceship with him was absolutely based on A, academic considerations than professional considerations. From the time he went to jail, my relationship with him ended. I was no longer giving him legal advice on a regular basis. I did not see him socially. So I did absolutely nothing wrong, and anybody who says I did is simply lying. Thanks for your question. I appreciate an opportunity to set the record straight. Hey, Paul, what's your point?
Hey, Alan, Baba Booey. Long time listener here, long time fan. And I just wanted to say in regards to Trump and the doctor thing, obviously I think that the friggin' doctors should have to listen to Trump. He's the president. Yeah, that's like the king of America, pretty much. And I feel like if you're working in America, or you're a doctor or whatever, you're a construction worker like I am, you should have to listen to the president. He's got the most authority. He's the smartest guy. The most people voted for him. He won the majority of the vote in 2016. And I don't know, it was some frickin' pansy doctor went to medical school for 10 years or whatever, is going to come in and tell the president what he has to do when he's out here busting his butt trying to save America? No, I don't think so. I don't think so, Alan. Like I said, long-time listener, long-time fan, Baba Booey. My name is Paul D'Angelo. Look forward to the show, Alan. Love you.
Hey, Paul, thanks for your very, very heated and interesting question, but I do have to correct you on a few points. President's not the king. The king is above the law. The president is subject to the law. Also, President Trump did not get the most popular votes. Hillary Clinton got 3 million more popular votes than he did, but President Trump won the election legitimately because under our constitutional system, the election is not determined by popular votes, it's determined by electoral votes, and he won fairly overwhelmingly an electoral college victory. Of course, whether you're the President of the United States or a construction worker like you, your doctor has to listen to you. You're the boss. You're in charge. It's your body. It's your life. The doctor has to be straight with you. And if you say to the doctor, I want to do this rather than that, doctor has no right to overrule you any more than a lawyer has the right to overrule you. The doctor can refuse to do it if he thinks it's bad for you medically. The Hippocratic Oath, first do no harm. But president's not a king. He's the commander-in-chief of the armed forces, which means he can tell military doctors what to do. But a good patient doesn't tell the doctor what to do. A good patient listens to the doctor, listens to the options, listens to the choices. And if there are choices, if there's surgery versus medication, yeah, you do want to leave it up to the patient. But I understand, the strong views you express, and I appreciate your listening to me, so thanks. So here's our last call for the day.
Hi, I prefer to remain anonymous since I don't really want to be on the record. But in answer to your question on Twitter, I'm a follower of yours. Yes, I do believe that the White House doctors answer to the people. The president serves at the pleasure of the people of the United States of America. And to that extent, I believe anything related to his health should be transparent and an open book to the people. So I'm not sure whether you're going to include my comment, but I thought I would answer your question. Thank you very much.
Excellent
Bye-bye.
question. And of course, I'm going to include it. And if you want to use your name next time, fine. If you want to call in anonymously, anybody, you can call in anonymously. There are no requirements of giving a name or a location. Look, if the rule is that doctors who work for the government can disclose confidential medical information, as long as the president or any patient knows that in advance, they can then make decisions. And my concern is that if it's widely known that a doctor who works for the government can disclose your medical secrets, you're less likely to give them your medical secrets, and it will reduce the quality of care. We make a trade-off in this country. We make it in the legal system, we make it medically, we make it with priests and ministers and rabbis, we make it with spouses. We say, look, we want you to communicate openly with your lawyer, your doctor, your husband, your wife, your rabbi, your priest. And so we're going to establish rules that do not permit the people with whom you confided to disclose that information without your consent. It's a trade-off. Sometimes we benefit from it, sometimes we don't benefit from it. But there's no free lunch. If you start disclosing information, you'll get less information. The same thing is true with journalists. The reason we have journalist privilege is because sources want to maintain secrecy and confidentiality. If we required journalists to disclose all of the information and the names of their sources, they'd have fewer sources. So these are trade-offs. Different countries have different trade-offs. The trade-off we've opted for is to promise confidentiality in some instances with exceptions. We have lots of exceptions to the rules of confidentiality. If a client were to come to me and say, I'm late, I have to leave here and murder my business partner, I would immediately have an obligation to call the police and tell them that my client has confided in me an intention to commit a future crime. That's an exception. Medically, there are exceptions. If you bring your child in and your child shows evidence of being abused, the doctor has an obligation to disclose that. But every time we have those exceptions, we create disincentives for the person to communicate with their professional. So a trade-off, great question. And look, we're going to keep asking hard questions on this show. I promise you a number of things. One, your answers will never be political or partisan. If you didn't know me in advance and you didn't read my writings, you wouldn't know from this show whether I'm a Democrat or a Republican, whether I'm a Trump voter or a Biden voter. That's not my job here to tell you how to think or who to vote for. My job is to help you analyze the situation from a legal, moral, and other perspective. So my promise, A, you'll never hear me being partisan on this show. B, you'll never be bored because the issues are so interesting, and I don't think I'm a boring person. So please keep calling, keep listening, and please stay tuned for future episodes of The Dirt Show. Remember, we'll take your calls 24/7, anytime, day or night. Make your call, and I will respond on The Dirt Show. Call our listener line at 216-710-0050. I want to hear your questions, your comments, your criticisms, and your opinions. Remember, all calls are recorded, and we reserve the right to use your questions and comments on the air. Once again, the listener line is 216-710-0050. I look forward to hearing from you. The Dirt Show is available on iTunes, Spotify, or wherever else you get your podcasts.